40 years back in November 1984, 4,006 were killed in Delhi, the capital of India. The genocide continued unabated for 3 days. Every minute, one Sikh was killed on the streets of Delhi. After the genocide, the guilty were given high positions and they were given the position of power. For 40 years, the victims are still waiting for justice. The cases for the justice to the victims are still continuing even now. I, H.S. Phoolka, a senior advocate, has been handling these cases right from number 1984 onwards. Through this video series, we have made an effort to bring to you how this massacre was planned. It's an effort to take you through the whole entire journey of this 14 years.
Welcome everyone to today's episode. My name is Neetika Khaitan and I am a lawyer pursuing a PhD in history at Yale University in the United States. It is my pleasure to welcome senior advocate H.S. Phoolka, who has litigated cases related to the 1984 anti-Sikh pogrom in Delhi from the very beginning. Thank you so much, Phoolka sir, for joining us again.
Thank you.
How is it that Sajjan Kumar finally came to be convicted by the High Court of Delhi?
See, it was not so easy after the Sajjan Kumar's acquittal from the trial court, and there were total 6 accused, 5 were convicted, and Sajjan Kumar was acquitted. The appeal was filed in the High Court. The CBI also filed, and we also filed the appeal. High Court admitted the appeal, and in the meantime, when the appeal was still pending in the High Court, in the meantime, as I have earlier also told you that I had joined politics, and when this appeal came up for hearing, that is the time when I was leader of opposition with the minister, the status of minister. I applied to the Bar Council that I should be permitted to do this one case. The Bar Council did not accept my request, and they said, since you have a status of minister, you cannot handle this case. Anyhow, I resigned from there and I started following up the case and doing this case. This was in July in 2017. In July 2017, the case came up for final hearing. The final hearing started. But somehow the case was delayed in this. In the meantime, a parallel case was going on in the Supreme Court. That was a case. When this government came in power, the NDA government came in power in 2014, there was a demand, there was a lot of pressure on them to reinvestigate the cases which are closed by police. 241 cases were closed by police as per the Nanavati report. So we built a pressure on them that you should reinvestigate these cases. So the government appointed a committee, G.P. Mathur, a retired judge of Supreme Court. G.P. Mathur committee was appointed. G.P. Mathur committee recommended that these cases deserve to be reinvestigated, and a SIT should be formed. So the Modi government formed a SIT. That SIT was holding the investigation, and in 2016, toward the end of 2016, they closed 199 cases out of these 241 cases. So the petition was filed in the Supreme Court by one person, Gurlal Singh Kalo, that this SIT has closed 199 cases. So the Supreme Court first asked for this matter came up before Justice Mishra, Deepak Mishra in the Supreme Court. So I was also appearing for one of the victims over there. So when we told the Supreme Court that these cases have been wrongly closed, the Supreme Court appointed a supervisory body. And that supervisory body, this is the order of 16th August 2016. 16th August 2017, I'm sorry. The Supreme Court appointed a supervisory body of 2 judges, and of the retired judges of Supreme Court, Justice J.M. Panchal and Justice Radhakrishna. They asked the supervisory committee that all these files of 199 cases, they asked the Supreme Court Director of the SIT to produce these files, and the supervisory body should go into this and recommend that if the cases are rightly closed by the SIT and or they have not conducted proper investigation. This is the order of 16th August, and in this para they have mentioned about this this committee, and the Supreme Court says, having heard Arvind Datar and H.S. Phoolka, learned senior counsel for the petitioner, and the Tushar Mehta, Pinky Nanda, learned additional Solicitor General, we constitute a supervisory body of 2 former judges of this court, namely Justice Panchal and Justice KSP Radhakrishnan, who shall scrutinize 199 matters which have been closed and express the view whether there was justification in closing these cases. And after this committee submitted the report. This committee submitted a report in December, and in December, this matter came up for hearing before the Supreme Court on 10th January. On 10th January, Supreme Court passed this order. We have perused the report of the supervisory committee. On a perusal of the same, we find that the SIT has not done further investigation in respect of 186 cases. Regard being had to the nature of the case, we think it appropriate that the fresh SIT should be constituted for carrying on the further investigation. Pinky Nand, learned Additional Solicitor General, appearing on behalf of the union, and Mr. H.S. Phoolka, appearing as senior counsel on behalf of the victims, shall file the 3 names consisting of a former judge, a former IPS officer not below the rank of IG, and a presently working IPS officer to constitute this SIT. Now, you see, on 11th, the Supreme Court passed this 11th next day. They listed matter the next day. On 11th January 2018, Supreme Court passed this the order constituting this SIT because there were common name in the list given by us and by the government, and that common name was Justice S.N. Tingra. Now, Justice S.N. Tingra is the same judge who had passed maximum number of convictions in 1984 cases. He is the same judge who had sent H.K.L. Bhagat to jail. And so this is SIT, Justice S.N. Tingra, former judge of Delhi High Court, Rajdeep Singh, IPS officer, and Abhishek Dular. This SIT, the Supreme Court constituted in January 2018 after 34 years. You see, earlier the impression which was going around that so many years have passed, 33, 34 years have passed, you are still talking about the old wounds, don't reopen the old wounds. That entire argument, that with the appointment of the SIT, those arguments fell, and the appointment of the SIT was a clear message to the judiciary and also to the public that justice need to be done in these matters. Even if 34 years have passed, justice has not been done. Justice Deepak Mishra clearly mentioned in the court that the community is still feeling hurt, that justice has not been done. So with the appointment of this fresh SIT, like I told you earlier also, that when I resigned, it appeared in the newspaper, the issue came in focus. But with the appointment of the SIT, the issue became a current issue, not a 34-year-old stale issue. It became a current issue. The approach of all the courts, approach of even the police officer, everybody's approach changed. Everybody say that something need to be done in this case. So after that, what happened? Judge Ajay Pandey, this SIT, which was formed by the government, they had filed a charge sheet against one matter that was tried by Ajay Pandey additional session judge. He convicted those accused and he gave death sentence to one and life imprisonment to the other. This happened in October 2018. During those days, the arguments of the case in Sajjan Kumar case in the High Court was going on. Fortunately, the matter came up before the bench of Justice Muralidhar and Justice Vinod Goyal. And Justice Muralidhar was known as an upright judge and a judge who is pro-human rights and pro-freedom and a very strict judge. And ultimately, after the arguments, I'll narrate you what those arguments also, what all went. On 18th December 2018, Justice Muralidhar accepted our appeal, convicted Sajjan Kumar, and also convicted Sajjan Kumar for life imprisonment till death, and also convicted upheld the conviction of those 5 people along with Sajjan Kumar. Among them was Mahendra Yadav, a former MLA. Among them was Balwant Khokhar, a former councillor. So this was a great moment, not only for us, for the country. This was for the first time that a people of this level in any mob violence cases were being convicted by the High Court. And that is such a remarkable judgment. The judgment which deals with the law of genocide. And I will narrate you about the details of the judgment, but that this brings a new era, not only for the victims, but for the whole country, as far as this justice in the mob violence cases is concerned. Sajjan Kumar filed an appeal against Muralidhar judgment in the Supreme Court. Actually, Justice Muralidhar in his judgment did not order the immediate arrest of Sajjan Kumar. He gave him 2 weeks' time to surrender. So Sajjan Kumar filed the appeal in the Supreme Court. He tried that appeal should be heard on priority basis. Supreme Court didn't agree. So ultimately he had to surrender, and his appeal came up for hearing for the first time on 14th of January 2019 before the bench of Chief Justice Gogoi, and Sanjay Kishan Kaur was with him. And on that day, they asked the CBI to file the reply to the bail application, because since he was seeking bail. The next hearing on 25th of February 2019, when his bail was to be heard, the matter came up before the bench of the Chief Justice Gogoi and Justice Sanjeev Khanna. Justice Sanjeev Khanna, he recused himself from the matter because he had dealt with this case in the High Court. As a result of that, the matter goes to the bench of Justice Bobde, who was number 2 in the Supreme Court. Then this carried on before Justice Bobde. Justice Bobde didn't grant him bail, and Sajjan Kumar tried his best that he is not well, his weight is reduced. Then he even brought the certificates from his private doctors, but he said, I want to get treatment done. The Justice Bobde directed the AIIMS to constitute a board to examine him. The AIIMS board conducted the medical examination, and they came out with it that he is not suffering from any serious ailment. There are minor ailments which can be treated in the jail. Ultimately, he came out with the certificate from Medanta that he has a suspected cancer. So he says, I want to be treated for cancer in Medanta, so grant me the medical leave. The matter came up before Justice Sanjay Kishan Kaur's bench. Justice Sanjay Kishan Kaur said, you go to AIIMS, the AIIMS will examine you. He said, no, I want it from Medanta. So Justice Kaur told his lawyer that don't expect a VIP treatment from us. Don't think Medanta is above the All India Institute of Medical Sciences. We are sending you to All India Institute of Medical Sciences. They will examine you. The report from the All India Medical Sciences came that he is not suffering from any cancer. Then his lawyer says he has reduced 10 kilo weight. Justice Kaur said, what did you expect in the jail? What will you do? Obviously, he will reduce weight in the jail. So ultimately, Justice called dismissed the bail application and directed that the matter will come up on hearing at its turn. Now his appeal is pending in Supreme Court.
How many cases are currently pending that are related to the 84 violence?
See, there are 4 cases pending against Sajjan Kumar, one against Jagdish Titler, and there are other cases also pending. Now against Sajjan Kumar, the other case of Sultanpuri, he was convicted in this delinquent case, and in the other case of Sultanpuri, in that he has been acquitted, and the appeal is filed in the High Court, and the appeal is pending in the High Court. One case is of Sarswati Bihar Police Station, that's pending against Sajjan Kumar, that's pending trial, it's going on in the Rouse Avenue Court. And one case of Vakaspuri Police Station, that is also pending trial, that's also pending in the Rouse Avenue Court. This is against Sajjan Kumar. And as far as Jagdish Title is concerned, his case is also pending trial for the murder of 3 cases. And apart from him, the other case where the death sentence was awarded by Ajay Pandey, that the appeal of the accused is pending in High Court. And apart from this, there are other cases, 2-3 cases pending in the High Court, one case is pending in Shadra, one case is pending in Tisajari. In total, about 12 cases, other cases pertaining to 84 killings of the Sikhs are pending now, different and various courts now.
My name is Prabhsahay Kaur. I am a lawyer practicing in the Delhi High Court and Supreme Court of India. I have been assisting in the cases of the 1984 carnage, and I also have the honor of being born into the distinguished family of Sardar H.S. Phoolka and his wife Maninder Kaur Phoolka. In a capacity of a lawyer and in the capacity of a daughter, I have been trying my level best to be able to be of assistance. In this arduous journey of many decades, one watershed moment was the judgment rendered by the Delhi High Court on 17th December 2018, convicting Sajjan Kumar and certain other people, but the judgment is landmark for the conviction of Sajjan Kumar. The day 17th December 2018 will remain etched in my memory forever. When this landmark judgment was passed, I'm always going to remember that courtroom. 2 remarkable men, known and distinguished for their wisdom and their composure, had a rare show of emotion on the day. My father, Mr. Phoolka, as soon as the judgment was pronounced, broke down. As his daughter, I have rarely ever seen him cry, probably never. And I saw tears in his eyes. He was unable to move for many moments. For someone who has been fighting alone, like the last man standing, this arduous, exasperating, extremely difficult and challenging battle for many decades, finally the truth had prevailed and there were tears of relief. The other person who displayed the emotion was Honorable Justice Muralidhar, a man known for always only having a smile on his face, pronounced the judgment with anger, with outrage. A man that we have only always seen smiling, even in very difficult circumstances. I've never seen such anger on his face, and mostly nobody in court had. That outrage was at these accused, was at these people that had managed to take our judicial system, managed to take the constitution for a ride for so many decades. It was as if the court was saying, finally, it has taken us all this time to get to you. You have misused the system for so long, the system we swear by, the system that gives justice to the innocent. And here there are people who have been wronged twice over. One, by losing their loved ones, and secondly, by having to wait so many decades for justice to be done. And for this very long legal journey, but also because it is extremely important as a judgment for the entire legal system of our country. So the judgment starts with a comparison of the 1984 carnage with the partition of the country of 1947. The beginning paragraph of the judgment itself shows the sensitivity with which it's been written. The Honorable Judge, Justice Murlidhar, who has penned this judgment, has started with a poem of Amrita Pritam, who had to flee Lahore, which was her home at that time, with her two little children. And it quotes her poem, and it says, "The seeds of hatred have grown high, bloodshed is everywhere. Poisoned breeze in forest turned bamboo flutes into snakes. Their venom has turned the bright and rosy Punjab all blue. The killings would continue in the streets of Delhi." The court then goes on to say that the majority of perpetrators of this crime enjoyed political patronage and were actively aided by indifferent law enforcement agencies, such that they escaped prosecution, they escaped punishment for over many decades. The particular case in question arose from an investigation done by CBI with respect to the murder of 5 Sikhs in the Rajnagar Part 1 area of Palam Colony, Delhi, and the burning of a Gurdwara in Rajnagar Part 2. The trial started only in 2010 and it resulted in a judgment of 2013 where 5 accused were convicted. However, Sajjan Kumar was acquitted. The 5 accused that were convicted were 3 for murder and 2 for armed robbery. The CBI filed appeals challenging the acquittal of Sajjan Kumar, as well as the accused also filed their appeals. The crux of the judgment is that the acquittal of Sajjan Kumar was reversed. He was convicted of multiple offences, including criminal conspiracy, abetment to murder, promoting enmity between different groups on grounds of religion, doing acts prejudicial to maintenance of communal harmony, defiling and destruction of a Gurdwara by burning. There is a certain paragraph from this judgment that I'd like to read. The accused in this case have been brought to justice primarily on account of the courage and perseverance of 3 eyewitnesses. Jagdish Kaur, whose husband, son and 3 cousins were the 5 killed, Jagsher Singh, another cousin of Jagdish Kaur, and Nirpreet Kaur, who saw the Gurdwara being burnt down and her father being burnt alive by raging mobs. It is only after CBI entered the scene that they were able to be assured and they spoke up. Admirably, they stuck firm to their truth at the trial. This court is of the view that the mass killings of Sikhs in Delhi and elsewhere in November 1984 were in fact crimes against humanity. They will continue to shock the collective conscience of society for a long time to come. While it is undeniable that it has taken over 3 decades to bring the accused in this case to justice, and that our criminal justice system stands severely tested in that process, it is essential in a democracy governed by the rule of law to be able to call out those responsible for such mass crimes. It is important to assure those countless victims waiting patiently that despite the challenges, truth will prevail and justice will be done. This is the fulcrum of the judgment. The fact that the court has recognized that this was a crime against humanity, and the fact that the accused managed to thwart the course of justice for 3 decades and even more. This, according to me, is the most important part of this judgment. It is a recognition of the fight of the victims, the fight of the families, the fight of the legal team, the fight of Mr. Phoolka, the fight that went on and on and on and faced so many struggles. For a court to write in its judgment that the accused managed to misuse the system and managed to run away from the course of justice for such a long time and managed to overawe and overpower our law enforcement agencies is an extremely important finding. The Herculean task in front of the legal team was to convince the Honorable Court that what 10 commissions and committees of inquiries did not do, what courts did not do for 40 long years, there is cause for this court to do. And the defense wanted to take advantage simply of the passage of time and try and convince the court that for the past 40 years, nothing has been done against Sajjan Kumar because there is no case against him. In order to take home this point, Mr. Phoolka raised instances before the Honorable Court of the political influence and clout that is shared by Sajjan Kumar. The argument before the court was that the witnesses were not made to feel secure. They were never made to feel that justice would actually be done. And in cases of crimes against humanity, it is the duty of the state to first be able to give witness protection to the witness and only then expect a witness to come forward. In this case, it was the opposite that was happening. Anyone who was speaking up, either meeting very bad fate or it was reaching a dead end because nothing was happening. Certain instances were given to show this, and these instances are important because the court has recognized all of these. Back in 1984-85, there were about 11 to 12 affidavits that were submitted in which the name of Sajjan Kumar features. And this is pointed out in an evidence of the defense witness 10, who is one Inspector R.K. Jha. However, this didn't lead anywhere. This was only the beginning of the attempt to ensure that at every stage Sajjan Kumar is shielded. In 1990, when the CBI proceeded to Sajjan Kumar's residence to arrest him, the jeeps of CBI were burnt and the CBI officers were kept hostage in his house. Now, a man that enjoys political clout and power and a criminal mindset to this extent that government officers can be kept hostage, how is it expected of victims who have already lost their loved ones brutally in front of them, murdered in the worst possible manner, to come forward and give evidence against him without being made to feel secure and safe that whatever is left of their families and their own life will be secure? The other example that was given and has been noted by the court is one FIR 67 of 1987, which was registered at police station Nangloi. Here, the statement of one Gurbachan Singh was recorded where he categorically named Sajjan Kumar. 2 affidavits were also given by him before the Mishra Commission, again naming Sajjan Kumar. Yet, the police recommended for filing of a closure report. The prosecution branch refused to accept this and recommended filing of a charge sheet by the police. The police then, accordingly, according to the opinion of the prosecution branch, prepared a charge sheet naming Sajjan Kumar. But this is where it gets interesting. The charge sheet never came to be filed. There was a conspiracy made where this FIR was clubbed with other FIRs, and in the process of that clubbing, other accused came to be named, and lo and behold, Sajjan Kumar's name was dropped. It is only in 2010, when the Honorable Court appointed a special public prosecutor, that the special public prosecutor found a challan of this FIR number 67 of 1987 lying in the police files, and he therefore moved an application before the court seeking summoning of accused according to this charge sheet that never saw the light of the day. In that matter, the court directed that it should be dealt with in accordance with law. However, till date, the said charge sheet was not filed, at least till the date of passing of the judgment. The next example given by Mr. Phoolka was that when Justice Nanavati Commission recommended registration of cases against Sajjan Kumar and Jagdish Titler, the government at the time flatly refused to accept the recommendations. A commission of inquiry of a retired judge flatly refused by the government. It doesn't happen every day. It is only when the parliament could not function for 3 days and was absolutely stalled did the government come under pressure and they had to accept the recommendation. These examples showed, coupled with the fact that the state completely failed to provide any kind of witness protection to the witnesses. Why would the witnesses feel that them coming forward, risking their lives, risking their loved ones, would actually lead to Sajjan Kumar facing music for what he has done? Here the court has very importantly said, relying upon certain judgments of the Supreme Court that we had cited, that the onus to prosecute an accused in cases of crimes against humanity lies entirely on the civil administration and the state, not on the victim. The victims and the witnesses have to be given the confidence to be able to speak up. Until the state is in a position to give them this confidence, they cannot be expected to come up on their own. A major part of this 200-page judgment is every possible conceivable attempt made by the defense team to raise submissions to save Sajjan Kumar. The court has dealt with each one of them and rejected every single one of them. Let the accused not feel that he's not been given a proper hearing. Let the accused not feel that he's not been dealt fairly by the law. Every single point has been dealt with by Honorable Justice Muralidhar. The court has also accepted that the witnesses had no reason to believe till 2006, when the CBI took over, that they had been completely abandoned by the state. Drawing a comparison with the 2002 Gujarat riots, the court has also said that while an SIT with the Gujarat riots was formed a long time back, no SIT was constituted for what the court has referred to as riots, but we would call carnage, till much later, till 2017. The prospects were so bleak. How could the witnesses be expected to come up? Let's talk about the facts of this case in particular. The court has said that we must dwell on the extraordinary circumstances in which this trial took place. The abject failure of the police to investigate into the crimes. The court has referred to the Punjab police rules, which are applicable in Delhi, and stated that there are two registers which are to be maintained in every police station. The first register is the FIR register, and the second register is the DD entry register. Where a person comes to a police station and discloses a cognizable offence, the entry is made in the DDR register and thereafter forwarded for a endorsement for recording of a formal FIR in the FIR register. Now, the court called for the DDR register of the particular police station, Palam Colony, for the period between 31st October 1984 to 6th November 1984. On a perusal of the DDR, the court noticed certain DD entries that deserved mention. Entry number 24 on 4th November 1984 states that there was a curfew in Rajnagar area. However, two constables heard certain people inside a house screaming, "If any Sardars have survived, they should not be left alive today." The constables asked them to stop, but they did not stop. They then entered the house and asked them to stop. However, they kept raising these slogans and were getting very aggressive. Because of this, they had to be arrested and they were brought to the police station and locked up. The other DD entry that is mentioned is that the constable has gone for patrolling. This is on 3rd November 1984 and has noticed the presence of RAC in the area. The court has therefore reached the conclusion that there are people openly breaking the curfew and asking, not only asking, but demanding that Sikhs should be murdered. And secondly, outside police force has been called, coupled with the fact that in this area there were 30 murders that took place. How is it that the DDR, the Daily Diary Register, is completely silent about the commission of any cognizable offence? According to the court, this itself not only raises questions but taints the entire action and of the police at the time. The court has referred to the DD register and the FIR register to show that despite multiple murders, and by multiple there are 30 murders, recorded murders in this area, there were no FIRs being recorded. There were no DD entries being made. It's abject failure of the police to even do any recording. So where is the question of proceeding to do any investigation? The court has therefore said that there was an utter failure to register separate FIRs with respect to each of the deaths which form subject matter of these appeals. The abject failure of the police to carry out their duties of maintenance of law and order has been called by the Honorable Court as a free for all during those couple of days, where over 2,700 people died. Honorable Justice Muralidhar has returned a specific finding that what happened in those days in October-November 1984 was a crime against humanity. It's best explained in his own words, and I will read from the judgment. In India, the riots in early November 1984, in which in Delhi alone 2,733 Sikhs and nearly 3,350 all over the country were brutally murdered, was neither the first instance of a mass crime nor tragically the last. The mass killings in Punjab, Delhi and elsewhere during the country's partition remains a collective, painful memory, as is the killings of innocent Sikhs in November 1984. There has been a familiar pattern of mass killings in Mumbai in 1993, in Gujarat in 2002, in Odisha in 2008 and in Muzaffarnagar in 2013, to name a few. Common to these mass crimes were the targeting of minorities and the attacks spearheaded by the dominant political actors being facilitated by the law enforcement agencies. The criminals responsible for the mass crimes have enjoyed political patronage and managed to evade prosecution and punishment. Bringing such criminals to justice poses a serious challenge to our legal system. As these appeals themselves demonstrate, decades pass by before they can be made answerable. This calls for strengthening the legal system. Neither crime against humanity nor genocide is part of our domestic law of crimes. This loophole needs to be addressed urgently. This judgment came back in 2018, and we can only hope that successive governments are hearing this. Finally, the truth prevailed, and accused number 1, Sajjan Kumar, was convicted under Section 302 IPC, 2 imprisonment for life for the remainder of his natural life.